Hi, everyone. Welcome to episode 72 of the Immigration Lawyers Podcast. This episode is going to be different from my usual podcast because I'm not going to be hosting this episode. My emphasis in this podcast has always been about continuing education for the National Immigration Bar and discussions and analysis about the practice of immigration law. So I decided to have a guest host today to talk about a topic that I don't focus on myself. My well-experienced colleague, business immigration attorney Giselle Carson, has been kind enough to present on the O-1A visa as an alternative to the H-1B visa. You can learn more about Giselle from my interview with her in episode 70. This episode is a great tutorial for beginners interested in representing O-1 clients, as well as more experienced practitioners, as Giselle discusses some of her own cases and AAO decisions on this topic. I hope you enjoy it as much as I did. Finally, if you have any questions or comments, please email me directly at info@jqqlaw.com. Also, please subscribe, like, and review the podcast on iTunes. Moreover, you can also subscribe and follow this podcast on our YouTube page, the Immigration Lawyers channel. Without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com.
Hello there, and welcome to the Immigration Lawyers Podcast. Today, we are going to talk about the O-1A visa as an alternative to the H-1B visas. My name is Giselle Carson. I am a business immigration attorney and a published author. I invite you to connect with me on LinkedIn and check out our show notes so that you get more information on what we're going to talk about today. And now let's get on to the show. So, U.S. employers, why are we talking about this? U.S. employers need foreign talent to add innovation and diversity to their workforce and to fill the critical talent needs and the skill gaps that we currently have. But as you probably know, there are no cap subjects H-1B is available until April of next year, and really until October of next year when those visas, work visas, become valid. So we as immigration attorneys are trying to look for alternative ways to provide employment authorization to our clients and give them options. And one of those options that we have been using successfully for those that qualify is the O-1A visa. So during this podcast, we're going to be sharing tips and talk about the current trends and AAO decisions that are helping us and hopefully will help you prepare the strongest O-1A petitions. I am very grateful to many people, but in particularly to John Khosravi for providing this forum, and also to Gabi Wenano, who is with my team, and she's joining me to facilitate this podcast, so you're not just listening to me for half an hour or 45 minutes. Gabi's family is from Ecuador, and in addition to being our immigration legal assistant, she's also an avid photographer, a sports fan, and a tech lover. So welcome, Gabi, and I know you're going to be asking me some questions, so what is the first question that you have for me relating to the O-1A?
Well, thank you for letting me join you. I'm excited to learn about the O-1A visa. What is an O-1A visa, and who can take advantage of this visa?
Sure. So O-1As it's a non-immigrant visa, and it's an employment-based visa, and it's for foreign nationals who can demonstrate that they have sustained national or international acclaim in very specific areas. So sciences, education, business, or athletics. So whenever I'm starting to consider an O, that's one of the first things that I'm going to check off my checklist. Is it applicable to the sciences, education, business, or athletics? For this particular visa, the beneficiary cannot self-sponsor, so they require either an employer and an agent who can file the petition on behalf of the beneficiary.
Are there variations to the O-1A visa?
Well, there are variations to the O-1. So, for example, there is the O-1A, which is the focus of our talk today. And that again is for extraordinary ability aliens in those specific fields. Then there is the O-1B, and that one is for individuals with extraordinary ability also, but particularly in the arts or extraordinary achievement in motion pictures or television. And then we have two others, the O-2, and that one is for individuals who will accompany the O-1 artist or athletes, and they're here to assist in a specific event or a particular performance. And last but not least is those dependents. So they come on O3. They're for the dependents, so the spouse and the qualifying children of the O-1As and the O-2.
So you mentioned before this is an alternative to the H-1B visa. What are the benefits that the O-1A visa can provide?
And again, on an immigration world where the cap subject H-1B visas have been on a lottery for a number of years now, 4 or 5, looking at alternatives like the O-1 becomes important and very strategic. And the O-1 is a much higher level of skills than the H-1, but it has also significant benefits. So, for example, it's not subject to the cap. So we can file an O-1 at any point during the year. There is no set level of education required, which can become really important in situations. For example, we have done many O-1s for individuals in business and athletics that do not have a bachelor's degree or a master's or anything like that. So their level of education and their experience really and their extraordinary ability they have gained as a result of their years of experience in the field and their unique talent. So no cap, no educational level required. Also the minimum wage. There is no minimum wage requirement for the O-1s. Also, no LCA requirement, no labor certification requirement like we have for the H-1Bs. And we have also used the O-1. In fact, I have a consult later this afternoon relating to this for physicians. So many physicians come to the United States using the J-1, which requires them or subjects them to the 2-year home residency requirement. And they cannot move onto an H-1B unless they obtain a waiver or they fulfill the 2-year home residency requirement. But if they qualify, they can apply for an O-1A. So that's another benefit of the O-1A visa.
How long can a person be on an O-1A visa?
Initially, the O-1s can apply for a 3-year maximum. The O-1s are related always to an event or an activity, and I'll talk a little bit more about that. So maximum of initially 3 years to complete that event or activity. And that event or activity can be a project, a lecture series, it could be a tour, it could be a business project, it could be a competition, it could be an academic year, or other kind of related engagement. A group of related activities, for example, a variety of tournaments, high-end tournaments, can be considered an event. And the period of that event may include vacations, promotional appearances, activities that are incidental to that main event. And this becomes important because after the initial 3 years, then we can request 1 year at a time to continue to participate or contribute to that initial event. But if we're able to show that the beneficiary is going to engage in a new event, then we can request another 3 years. And that really becomes very, very useful. So we have done quite a few initial 3 years and then multi-year O-1, new O-1. So where the beneficiary had their initial 3 years and now we're arguing that there has been a break in the initial event. We're requesting another 3 years. And I'm going to point you to some things that you can use and we have used to justify the new 3 years. And so the regulations under 8 CFR 214.2032 defines an event as including multiple activities but not limited to projects, conferences, conventions, lecture series, tours, exhibits, business projects, and engagements. So we have used that to say if a variety of activities constitute an event. We have also used the FAM, AF-FAM, at Chapter 33.4 E2, which provides that if the activities in the itinerary fall within the beneficiary's area of extraordinary ability, they generally will be considered a single event, no matter the gap between the U.S. engagements. Now, I try to keep the gap between the U.S. engagements as short as possible, because that helps. And there is also a USCIS policy memo that you can look at clarifying guidance on the O petition validity period. And that's a memo from July 20 of 2010. And we have also used that to justify or support a new event with 3 years. So again, in summary, initial 3 years with 1 year extensions, unless you can justify it or create a break between the main event and then argue that the beneficiary will come for a new event. And I typically counsel or process this new O-1 3 years, and that has worked well.
What are the general eligibility criteria for O-1A visas?
Yeah, so as I said before, I kind of call it a high-end visa because it's for people that really are at the top of their field. So in general, you have to show that the beneficiary has sustained national or international acclaim. And it's important to say sustained. So if it's someone that was really at the top of their field many years ago, but they have not been able to sustain that acclaim, you may not be able to argue in O-1. They must be coming to the United States to continue to work in the area of the extraordinary ability. Again, we see people that were very accomplished abroad in a particular field, but they want to come to the United States to do something else. Well, that would not qualify them necessarily for an O-1. And as I said before, we have to show that they are at the very top of their field. And in order to do that, we typically try to narrow the field as much as we can. So for example, if it's a researcher, the title of the position and the scope of the application is not just going to be a researcher. We're going to try to make them, with conjunction with our client, narrow their area of research as much as we can so that we can elevate them to the top of the field.
How can we establish that the beneficiary meet these evidentiary criteria?
The regulations provide for a list of evidence that can be submitted or must be submitted, really, in order to show that the beneficiary is at the top of their field. The first one is receive a major international recognized award, such as a Nobel Prize. We haven't had the opportunity to work with one of these beneficiaries yet, but I'm always keeping my doors open for that opportunity. So what we typically have to do is look at the other options beyond a Nobel Prize or something related to that. And in that category, you have to select and prove at least 3. So those include national or internationally recognized prizes or awards, memberships in certain associations, published material about the beneficiary and his work or her work, original scientific, scholarly or business-related contributions to the field, authorship of scholarly articles, a high salary or remuneration, participation on a panel or individually as the judge of the work of others, and last but not least, employment in a critical or essential capacity for organizations of distinguished reputations. Now, the regulations, the list that I've provided you have really condensed the wording. There is more words to these descriptions that actually have some meaning and impact, and we'll talk about some of those as we continue our conversation.
That's a lot to provide USCIS. How do you know what USCIS is looking for in each evidence criteria?
So that's a great question. Immigration attorneys, so what we do, obviously, we look at the law, we look at the regulations, we look at the FAMs, we look at the USCIS memos. But lately, I find myself looking a lot at the AAO decisions and trying to figure out what are the trends, what are the evidence that is being submitted, why USCIS is denying the cases, and how the AAO are looking at this evidence and making the decision as to what to do with the case. So in today's podcast, because we could be talking about each one of these criteria forever, we have selected three very recent AAO decisions that provide guidance on how to establish three out of the seven evidentiary criteria we talked about. So we're going to talk about how to establish original scientific and scholarly or business related contributions. We're going to talk about how to establish that the beneficiary is receiving or will receive a high salary remuneration, and finally, how to establish a critical or essential capacity.
So how can we establish original scientific, scholarly, or business-related contribution?
Now, remember what I said before, that almost every one of those words has a meaning, and this is one specific example of that. So, and as we talk about the decisions and how this is applied, each one of those words, original, scientific, scholarly, or business-related contributions, has a role to play in how we prepare our O-1A petitions. Let me start by saying that what is provided under the regulations, so the petitioner must establish that the beneficiary has not only made original contributions, but that the contributions are of major significance in the field. And again, that has to be a scientific, a scholarly, or business-related contribution. And a way of doing that is to show that the beneficiary's contributions have been widely implemented, or that they have influenced the field or otherwise risen to a level of major significance. I mentioned before, we work with researchers and we work with athletes, and in fact we're working now on a teacher's petition, and the way we have used this original contributions and showed that there were major contributions to the field is because, for example, in the case of our researcher, we have been able to obtain letters from other institutions that have been using the researchers' research to their facility and to the research that they have going underway. In the case of the teacher, the curriculum that she implemented has been followed by other schools, so has contributed to the field in that way. Business case that we're handling, the beneficiary led a certification for the company, and the process and systems that he implemented to obtain the certification have been followed by other organizations to achieve the same certification. So those are the examples of how you can show that the contributions are original and have impacted or have been implemented into the field. So again, we're doing this showing through letters of other organizations that are using the beneficiaries' contributions to further their organizational goals or to further the field. Something else that is important to know with this particular criteria is that the eligibility must be established at the time of the filing. So it's not, and I'll go into example. Actually, one of our cases that we have the three cases that I'm going to talk about. You can reference, or they're referenced on the show notes. And one of them, AAO matter of MKSP. And this is a November 2017 case. In that particular case, the petitioner submitted an unpublished research paper as evidence of an original scholarly contribution to the field. And the director denied the petition, and for various reasons, but this was one of them, basically saying that the criteria had not been met. And the reason the petition was denied, and the AAO basically said that is correct, is because the paper had not been published. So it was an unpublished paper, and so the decision reads, the paper has not yet been subject to the intended journal's peer review process or disseminated to the field. The record show that their proposed theory has not influenced the field. It will not count as a major original scientific contribution. So that is one example. Again, you can read more about it at the AAO matter of MKSP. But then let me give you another example where the AAO found that the original contributions, the implementation was met. And in that case, that's AAO matter of PSA, and actually that's a April, right? April 2018 case. And in that particular case, it was the beneficiary had developed soccer training manuals that were considered original contributions. So again, we have two prongs to satisfy. So original, they said, yeah, okay, those are original contributions, but that is again not enough. The regulations also require that we show that they are major contributions that are scientific, scholarly, or business-related contributions. In this particular case, the petitioner also submitted letters from others in the field basically saying that they had consistently utilized the beneficiary's manual and had achieved tremendous success in the growth and development of their young soccer players using the training manuals that the beneficiary had created and published. So that was an example of evidence that was submitted and that was accepted as original contribution that was being widely accepted. So there you go. Those are some examples of how we can establish original scientific, scholarly, or business-related contribution.
Now, you said before that we also are going to be talking about establishing high salary and remuneration. How can we establish that when here in the States, it's pretty well known that some of these researchers or teachers or athletes are being paid so much money?
Well, so that's a good question. So and let me start by giving you some websites that are going to be useful to you to establish high salary and remuneration, and they are also on our show notes. So there is bls.gov, careeronstop.org, and also the FLC Data Center, which I'm sure many of us use for our H-1B petitions. So those are websites that the government sites that, in fact, the USCIS also recommends that we use them in order to establish high salary and remuneration. And as to what Gabby mentioned, in fact, that was one of the arguments that one of the decisions that we're referencing mentions. The petitioner basically argued, well, it's well known that soccer players or coaches make a significant amount of money in commission. Actually, in this particular case, I think it was a coach. And actually, yeah, it was a coach. So this case is also in our show notes. It's AAO matter of PSA. And actually, I mentioned that one before. So it comes back up. It's in a 2018 case that also covers the issue of remuneration. And in that particular case, as Gabby kind of mentioned, the petitioner said, it's known in the industry that coaches receive a lot of commission income money. And basically the director, they denied the petition, and then the AO said, and the director, well, that's great, but you have to show us evidence, which you have not, that it is well known that, that the coaches receive a significant amount of commission in income. Now, I don't necessarily think that the sites that I just provided you with are going to show that commission income is high for coaches. To establish something like that, you would probably have to go to a private survey or private industry, or maybe get a letter from someone else, an expert that will support that. But that's what happened in that particular case. In another case that I mentioned before, actually, and it's referenced in our show notes, MKSP. That's that 2017 case. And in fact, I'm actually arguing. I don't typically argue high salary remuneration, because despite what Gabby said, that many of our clients to some degree earn a fairly high salary just because they are professionals, and particularly people that are at the top of their fields that tend to get paid certainly much more than minimum wage. But is it high enough to make it high salary remuneration for the purposes of extraordinary ability? And I've had very few clients clients that I've been able to argue that they're really at the top of their salary. And in fact, we're at least one client right now where we're using this criteria. And what we're showing, the way we're doing that is we're using the government databases to show that the average in the industry, and I'm just picking, is $100,000. Our client is making $250,000, plus he gets a lot of other incentives and bonuses and stock options and things like that. So he's really way beyond the average in the field, and we're using the government data to show this is the average, and he's well beyond the average. This matter of MKSP references also several INA decisions and actually Ninth Circuit decisions and other federal court decisions that also mention and deal with how to show remuneration and high salary. So if you are using this as one of your evidentiary criteria, I recommend that you read MKSP and the other cases that are referenced in that decision.
Now, for the last one, how do we establish that the beneficiary is in a critical or essential capacity?
So critical essential capacity, actually, let me kind of say in terms of the evidentiary criteria that at least for our cases, we end up using the most. Critical and essential capacity is one that we typically use. Original contributions of major significance to the field is another one that we typically use. Judging of the work of others, and this may be the subject for another podcast, but we end up using that criteria a fair amount if the foreign national does not have published articles or media, significant media coverage about their work. So critical and essential capacity, again, we're talking about people that are extraordinary in their fields. They're at the top of their field. Typically, this one is one that most likely you are going to be using. So it's always good to see what others are using in terms of the evidentiary criteria. So one of the cases that I have in the notes is the matter of PSA 2018 case. In this one, the critical essential capacity is literally 2 lines. Basically, the petitioners submitted letters showing that the beneficiary had been coaching at several prestigious soccer teams and clubs, and the beneficiary qualified. Then in matter of MKSP, again, letters were submitted that the beneficiary had served as a visiting professor of high energy and as an adjunct professor of physics. And he was conducting high energy physics research and assisting the petitioner. But in this particular case, so again, PKSP, the AAO and the director felt that the statements alone were not enough to demonstrate that the beneficiary had been employed in a critical or essential capacity for the colleges. So, and I'm seeing a lot more of this that before, and this even goes back to just a year ago, letters from employers, from prior employers, and from experts were typically enough, and even notarized statements were typically enough. And now the RFEs, in fact, I'm going to talk about one RFE that I just received yesterday about critical and essential capacity. We're seeing that just letters, even from prior employers on their letterheads, are not enough, that we have to show additional documentation that goes to support the statements on the letters. In this particular case, in MKSP, basically also the AO and said maybe they have played a critical role for the organization, but the evidence that was submitted did not differentiate the beneficiary from the college's other professors, and it was insufficient to establish that his specific role had contributed to those organizations in a way that was substantial to their success or standing. And again, I'm working on a T-shirts O-1 petition right now. So as I was preparing for this podcast and reading these decisions. I certainly make sure that in our case, we clearly, or at least as clear as we can, differentiate her role as an extraordinary teacher versus just a teacher that may not be completely at the top of their fields. They can be a good teacher, but not necessarily at the top of the field. And again, I just mentioned that we just received an RFE yesterday, which I these days you just never know what kind of RFE you're going to get from USCIS. But this particular one, we had submitted, as many of you probably know, you get the RFE and you say, but we submitted that. So this one, again, it's an O-1. We use critical and essential capacity. This was an athlete that is at the top of his field. And RFE says to assist in determining that the beneficiary has performed in a leading or critical role, the petitioner must specifically state which employment position and for which company the petitioner intends to qualify the beneficiary. And I'm kind of laughing behind because I'm going, well, we submitted letters from prior employers establishing that there were and supporting evidence that there were distinguished organizations in the field, distinguished teams, and that the athlete played a critical role and a key role in many of the accomplishments that the teams obtained. So I'm really not sure what USCIS wants to see in further evidence, but they go on to say the letter should contain detailed and probative information that specifically addresses how the beneficiary's role for the organization or establishment is or was leading or critical. Details should include the specific tasks or accomplishments of the beneficiary as compared to others who are employing similar pursuits within the field of endeavor. The letter should include the name, address, and title of the writer. Again, from my perspective, we submitted that evidence, but we're going to revisit this and try to strategize and see how we can submit it in a different fashion so that the adjudicator will reconsider the evidence and hopefully get an approval.
This seems just a lot for just 3 of the 7 or 8 really criteria that they allow us to choose from. How can the listeners learn more from what we just talked?
Sure. It is really important to stay connected in the field and of immigration these days, whether you're working in removal or business immigration or whatever, so that we can continue to help each other. So please reach out to me. I'm on LinkedIn, fairly active there, so we'd love to connect with you on LinkedIn. You can also email me at gc@marksgray.com. I look forward to hearing from you. Please let us know if you enjoy this podcast. What would you like to hear more about so that we can continue to share and learn with each other? And on that note, stay tuned for more educational podcasts. Talk to you soon.